Welcome back. This is Lee from the Law School Toolbox. So, what is accomplice liability? The basic idea is straightforward. Someone who helps another person commit a crime may be held liable for that crime as an accomplice, even if they don't personally commit any of the elements of the crime. But as we'll see, determining exactly when someone becomes an accomplice requires careful analysis. Accomplice liability requires 3 elements. First, someone else must commit a crime. We call this person the principal. Second, the accomplice must assist or encourage the principal in the commission of the crime. Third, the accomplice must have what is sometimes called dual intent. The accomplice must have the intent to assist the principal and the intent that the crime be committed. So let's break each of these elements down. For the first element, commission of a crime by the principal must actually commit a crime. If the principal's conduct is not actually a criminal act, or the crime is never committed, there can be no accomplice liability. However, the principal doesn't need to be caught or convicted for accomplice liability to attach. The second element, assistance or encouragement, can take many forms. An accomplice might provide supplies for the commission of the crime or act as a getaway driver or lookout. The accomplice might also verbally encourage the crime, for example, by yelling, "Kill him!" or by giving the principal advice or instructions about how to commit the crime. However, mere presence at the scene of a crime or knowledge that the crime may be committed is not enough to establish assistance or encouragement of the crime. The third element, the intent requirement, is often the trickiest. The accomplice must have the intent to assist the principal in committing the crime and the intent that the crime be committed. Accomplice liability does not attach if the person assisting the principal in the commission of the crime did not actually intend to provide the assistance. Additionally, in a few jurisdictions, a person can only be an accomplice of crimes requiring specific intent. Now that we've covered the main elements, we can talk about some situations where accomplice liability just doesn't apply and what defenses a person charged as an accomplice can assert. There are some situations where accomplice liability will not apply even when it looks like all the elements are met. For example, the victim of a crime cannot be an accomplice to the crime committed against them. Accomplice liability does not apply when the crime inherently involves several types of participants and the person is not criminally liable under the statute. Also, keep in mind that a minority of jurisdictions do not allow accomplice liability for involuntary manslaughter. A person charged as an accomplice can assert that they withdrew as a defense, but only if they withdrew before the crime was so far underway that it was unstoppable. Withdrawal can be accomplished by either repudiating any engagement, any encouragement given, or undoing any assistance provided. An accomplice can also notify the authorities or stop the crime from happening if they are unable to repudiate the encouragement or undo the assistance provided. What about liability for additional crimes committed by the principal? This is where things start to get interesting. Under the natural and probable consequences doctrine, an accomplice can be liable not only for the crime they intended to help with, but also any other crimes that were a reasonably foreseeable consequence of the intended crime. Now that we've covered the rules, let's work through some accomplice liability hypotheticals together to see how these concepts work. Here's our first hypo. Alice works as a bank teller. One day, her boyfriend Bob tells her he plans to rob the bank where she works. Alice thinks he's joking and laughs, saying, "Well, if you do, remember the real money is in the safe deposit boxes, not the teller drawers." She also mentions that the security guard takes his lunch at 1 p.m. The next day at 1:15 p.m., during the security guard's lunch break, Bob robs the bank at gunpoint. He gets the money from the teller's drawers and demands access to the safe deposit boxes. The safety deposit boxes can only be accessed with keys from 2 different managers, but only one is present, so Bob is unable to access them. During the robbery, a customer attempts to stop Bob, however, Bob shoots the customer. For this hypothetical, we need to analyze whether Alice could have been charged as an accomplice to both the robbery and the shooting. First, we need to determine whether Alice is an accomplice to the robbery. As a reminder, to establish accomplice liability, these elements must be met. 1. Commission of a crime by the principal. 2. Assistance or encouragement by the accomplice. And 3. Intent to assist the crime and intent that the crime be committed. Here we know that Bob, the principal, clearly committed the principal crime of armed robbery, so the first element is satisfied. Next, we need to look at what Alice actually did. Was it assistance or encouragement? Alice provided Bob pretty specific, helpful information about the guard's schedule, including when the bank would be unguarded. Rob was able to use that knowledge to commit the robbery because he knew exactly when the bank would be vulnerable. Her statement about the safety deposit boxes is less clear, though it does seem like she was encouraging him to access the safety deposit boxes. So as to the second element, Alice's statements seem to be assisting and encouraging Bob's planned robbery. The intent element is going to be the hardest element to prove in this hypothetical. Alice's belief that Bob was joking suggests she didn't actually intend to help him commit a robbery. Alice will argue that her statements were clearly a joke and were not intended to assist or encourage Bob. Since we know Bob couldn't get access to the safe deposit boxes during the robbery, Alice might explain that she knew it wouldn't be possible to get to the real money, which suggests that she didn't have the intent to help or encourage Bob, and she didn't have the intent that he actually commit the crime. The prosecution might argue that giving such specific information shows she believed Bob would rob the bank, and that she would not have provided him that information unless she both intended to help him do so and intended that he complete the robbery. This is not really a slam dunk in Alice's favor or against her, so Alice might leave the question of her liability as Bob's accomplice for the armed robbery to the jury. Okay, let's look at the second issue in this hypothetical: whether Alice can be held liable for the shooting under the natural and probable consequences doctrine. Remember, the rule here is that in addition to any crimes that the accomplice helped with, the accomplice is liable for any reasonably foreseeable crimes that the principal commits. For this discussion, let's assume Alice is liable as an accomplice to the robbery. The first thing to remember is that Alice does not need to have assisted or encouraged Bob in the shooting, nor do we have to find that she had any intent to assist or encourage him. We also don't need to know whether she intended for him to shoot anyone. What we're looking at here is whether a shooting that occurs during an armed bank robbery is a reasonably foreseeable consequence of the armed robbery. That is, was Bob shooting someone who intervened during this armed robbery a natural and probable consequence of the armed robbery itself? Alice might argue that it wasn't reasonably foreseeable that a customer would intervene or that Bob would shoot the customer because Bob didn't tell her he planned to bring a gun to the robbery. On the other hand, the prosecution would argue that it is reasonably foreseeable that Bob would bring a gun to the robbery because robbing a bank is often done at gunpoint, and therefore, it was also reasonably foreseeable that someone at the bank would be shot while Bob was committing the robbery. The prosecution's argument is the most likely winner here because it is reasonably foreseeable that during an armed bank robbery, someone may be shot due to the nature of the crime. Here's a small plot twist to the fact pattern for us to think about. The day after Bob tells Alice he plans to rob the bank, as Alice is leaving for her lunch break, she runs into Bob outside the bank. Alice realizes he had not been joking during their earlier conversation and says to Bob, "I hope you know I was just joking around. You can't get into the safe deposit boxes, and we actually have a guard on duty all the time. Don't rob the bank. It's a terrible idea." After they part ways, Bob returns to the bank and robs it at gunpoint as he planned. Does this change the analysis of whether Alice is an accomplice for the armed robbery? Remember that a defense to accomplice liability is the accomplice's withdrawal by repudiating any encouragement or undoing any assistance provided before the crime is unstoppable. Alice would be able to assert that as soon as she realized Bob had been encouraged by her comments and that her comments about the safe deposit boxes and guards might have helped him plan the robbery, She clarified she was joking, explained that the comments regarding the safe deposit boxes and guards weren't actually true, and told him she did not support him robbing the bank. Bob hadn't even entered the bank yet. He could have turned around and left, so the crime was still stoppable when she repudiated her encouragement and undid her assistance. Alice has a solid defense based on withdrawal in this factual scenario. All right, let's look at a second hypo. Tom manages an electronics store. During work one day, Tom's employee Mike, who is angry about the low wages both he and Tom are paid, suggests to Tom that they burglarize the store that night after closing. Tom tells Mike that he wants nothing to do with the plan. However, Tom intentionally leaves the store's back door unlocked and turns off the security cameras before he leaves that night. Mike returns to the store after it is closed and enters through the unlocked back door. Mike steals several expensive items, but also decides on a whim to vandalize the store and to set a small fire that damages the store. So let's analyze Tom's potential criminal liability under accomplice liability principles. Just like the last hypo, we'll look at whether Tom is an accomplice to the burglary first. Here, Mike committed the principal crime of burglary, so the first element is met. There's a strong argument here that Tom's actions in leaving the door unlocked and disabling the security cameras actively helped facilitate the burglary. Tom doesn't have a very good argument to the contrary because he engaged in two very intentional acts that left the store unsecured when he knew that Mike was planning to burglarize it. This is true even if Tom didn't tell Mike he was going to do either of these things. So the second element, assisting or encouraging, is met. Looking at the intent element, we know that Tom verbally refused to participate. So he would probably argue that his words indicate that he did not intend for his store to be burglarized, nor did he intend to help Mike do so. However, his actions in deliberately creating the conditions to help the burglary succeed demonstrate his true intent. Tom's act of leaving the door unlocked assisted Mike in allowing him easy entry into the store, and Tom's act of turning the cameras off assisted Mike by allowing him to do whatever he wanted in the store without being seen. Since it is not a normal business practice to leave a store completely open and unattended, and he did it the very night Mike said he was going to commit the burglary, we can infer that Tom intended to assist Mike in burglarizing the store and that he wanted Mike to commit the burglary. Therefore, we can conclude that despite Tom's verbal protests, his actions made him an accomplice to the burglary. Okay, now we need to think about whether Tom can be held liable for the vandalism and the arson that Mike committed during the burglary under the natural and probable consequences doctrine. While the property damage from Mike's vandalism might be a natural and probable consequence of a burglary, depending on what exactly Mike did to vandalize the store, Mike's act of setting a fire likely goes beyond what Tom could have reasonably foreseen when he assisted Mike in committing the burglary. Remember that the natural and probable consequences doctrine doesn't extend to crimes that are not reasonably foreseeable. So overall, Tom would likely be liable as an accomplice to the burglary, and he might be held liable as an accomplice to the vandalism, but he wouldn't be liable for the arson. The last two hypotheticals show us how accomplice liability requires careful analysis of the accomplice's thoughts and actions before the crime, along with what a natural and probable consequence of any given crime might be. Even seemingly small actions can create criminal liability if they're intended to help a crime succeed. And an accomplice can easily find themselves in trouble for multiple crimes committed by the principal. Let's explore one more hypothetical. Here's our scenario. Rachel works as a bartender at an upscale restaurant. She notices that her wealthy, regular customer, William, always pays with high-limit credit cards. Rachel mentions this to her cousin David, a computer expert with a history of credit card fraud. She gives David William's full name, the types of cards he uses, and his usual dining schedule. She tells David, "You're always talking about how easy it is to clone credit cards. I bet you could get some money fast off this guy." David visits the bar during William's usual dining time and takes a seat next to William, which allows David to successfully create cloned versions of William's credit cards. Instead of just using William's credit card information to withdraw cash or buy things for himself as Rachel expected, David uses William's credit card information to create fake identities, which he then uses to commit large-scale bank fraud. Now let's analyze this hypo. As always, we need to look at whether Rachel is an accomplice to the first crime, which is larceny. Recall that our accomplice liability rules require 1. A principal crime, 2. Assistance or encouragement by the accomplice, 3. The dual intent to encourage or assist the crime, and that the crime be committed. We know that David committed the principal crime of larceny when he stole William's credit card information, so the first element is satisfied. The second element is also pretty clearly satisfied. Rachel's assistance was providing David specific information about William, his credit cards, and his schedule. She also encouraged David by specifically suggesting that David engage in the criminal activity. So we can confidently say that the second element has been satisfied. Similarly, the intent element is easily satisfied here because Rachel initiated the discussion with David, provided David with details necessary to commit the crime, and actually told David he should do it. We can infer from those actions that Rachel had the dual intent to assist in the crime and that the crime actually take place. Since all the elements are met, we can conclude that Rachel is an accomplice to David's crime of larceny. The harder question is whether accomplice liability extends to David's second crime of bank fraud. Just like the other two fact patterns, we're looking at the natural and probable consequences doctrine. Rachel might argue that she couldn't reasonably foresee that David would take the larceny of William's credit card information to the next level, since she only knew of David's credit card fraud history and thought he would just use the information to withdraw cash or buy himself things. On the other hand, David's act of using William's credit card information to commit other significant financial crimes is a typical pattern criminals use after stealing someone's personal financial information. Rachel's comments seem to confirm this too, since he thought that David could make a lot of money off of William, which implies that he could do more than just use the information to obtain cash and buy himself things. Given these comments, there's a strong argument that it was reasonably foreseeable that in addition to, or maybe instead of, stealing and using William's credit card information for himself, David would also use it to commit other crimes. So David's additional crime of bank fraud is a reasonably foreseeable consequence of the intended crime. And Rachel would likely be held liable as an accomplice for both of these crimes under the natural and probable consequences doctrine. So this hypothetical shows us how accomplice liability can extend to significant crimes when a relatively simple criminal scheme expands into something much larger. And that's all we have time for today. If you enjoyed this episode, please give us a like, leave us a comment, and subscribe so you don't miss any future content. And you can learn more about us at lawschooltoolbox.com.